schedules work, so it actually worked today. No thanks to me, I'm the absent-minded professor. My flight was at 9:45, but I thought it was at 7, so I show up at the airport at 5. And so I had 3 breakfasts and 3 cups of coffee, so I'm ready to go now. But this topic of GINA is something I think everybody kind of has an opinion about. It has been regarded as a sort of ineffectual piece of civil rights legislation, and that's mainly because its nameplate provisions are this thing banning genetic discrimination in employment and another one banning it in health insurance. And the problem was there was not much evidence that that was happening, and so it sort of solved a problem that seemingly didn't exist. And for about 10 years, that was how we thought of GINA. And about a year ago, I was stumbling through it looking for something, and I realized it has these really important privacy provisions that are embedded in there, and they're kind of hidden in the insurance provisions. And there are these very powerful rights that Congress was giving Americans, and it was mainly making sure that all of your genetic information would be protected by the HIPAA privacy rule, even if the genetic information wasn't quite what we would think of as health information. As I'm sure you all know, when you do modern genome sequencing, you just get these gobs of data that you produce. And at this point in our learning trajectory, we don't know what most of those variants do. There are about 200 that have been clearly associated with disease conditions such that we can say if you've got that variant, we can tell you something about your future health. The rest of it is just 10,000 variants that most of us would have in our exome, which is the part of the genome where our genes are. We aren't quite sure yet, and we're still finding out, and I think we'll be working on that for a couple of 100 years. Those data were not under privacy protections, and so Congress got this idea of let's just protect all of it and make sure that people's data are protected with what some people consider the minimal privacy protections of HIPAA, but we didn't even have that before. And that included this right of access to your data. And regulations were promulgated in 2014 to effectuate that so that you could get your genomic data under HIPAA's access right at any HIPAA-covered facility, which is usually healthcare institutions, but a lot of research laboratories are HIPAA-covered as a result of being affiliated with an academic medical center, such as I'm sure is happening on this campus. You've got research labs affiliated with the hospital, and so they are HIPAA-covered. That created great angst because there has been kind of a 20-year track developing this idea of returning results in research. And that is not a legal requirement, but an ethical practice that has grown. And it was first mentioned in the literature in about 1980 that when we get people in and ask them to volunteer for research and we're generating data about them, maybe they have some sort of an ethical right to receive those data. And it originally kind of grew up out of the thought of a duty to warn, that in a lot of modern research we're doing extensive workups of the research participants so that we may sequence their genome, we may take extensive imaging, diagnostic imaging testing, and in the course of the research, the researchers may become aware that the person has a condition that could need some clinical follow-up. Even though the purpose of the research isn't to treat the patient, it seemed unethical if a researcher could see that you had a tumor not to tell you about it. And so it originally sort of grew out of the duty to warn that maybe there was an ethical duty in research to share enough of people's research data with them that they could seek follow-up care when indicated. More recently, that notion has expanded to a broader ethical right that is to respect people's autonomy, let them, treat them more as partners in research, get them more engaged with the research. And so it's kind of gone beyond just serving a duty to warn at this point. But in guidelines since about 1999, it has become very common practice in biomedical research to have some ethical return of results to the participants. And in the course of that debate about this ethical practice of returning results, there has been voiced a lot of concern that maybe the research subjects are too unsophisticated, that they may become unduly alarmed by the data, or they may make bad medical decisions, or they may fail to understand how uncertain the data are. And this leads a lot of institutional review boards, which are the bodies that oversee the conduct of research under the big research regulation, the common rule, to limit return of results and be concerned that sharing uncertain research information could be harmful. So that's one strand of thought that's lasted for about 20 years. This privacy right under HIPAA is a completely different thing, and it has a completely different origin that I confess I was not aware of until I started researching it. It goes back almost 50 years, and it's a very well-established privacy right that starts in the 1970s. And the notion was that in the information age, we've sort of given up defining privacy in terms of secrecy and being able to conceal your data so no one else can see it. It's sort of a given that the social benefits of using people's data in public health uses, for research uses, for regulatory uses, are so great that basically Congress has made a decision that people are not going to get to veto uses of their data in all circumstances. They have a limited consent right that lets them have some control over their data, but all of our federal privacy laws allow pretty substantial sharing of your data without your consent. Hopefully in de-identified form, but not always. Public health users can get your fully identified data, and that's lawful. And as things developed in the 70s, Congress put a lot of effort into trying to define what should you get in return if your data are going to be shared without your consent. And they determined that at a minimum, you should at least be able to see your data yourself so that you can judge how big a privacy risk you are incurring as a result of this widespread sharing that's going on. That thought is embodied in the Privacy Act of 1974, which is a law that deals with data in governmental databases. And Congress made this weird statement that I mentioned in the paper you read. They made a congressional finding of a legal fact, which is a very odd beast that we rarely see in law, and it's an enacted finding of fact. And most congressional findings of facts are flowery language that Congress says before the law begins, kind of a preamble. An enacted finding of fact is actually part of the statute and is put in the US Code. And Congress made this statement that the right of data privacy is a fundamental right protected by the Constitution, and that it's necessary and proper that people should have certain rights to effectuate that. And one of them is access to their data. Now that doesn't mean that data access really is a fundamental right. Congress in our constitutional system isn't the entity that decides what the Constitution says, the courts do. But courts pay attention to enacted findings, and they have some weight. And so Congress stated this principle in 1974 that we think this is a really important enabler of constitutional protections for people to be able to get their own data. And at this point, I just want to stop and kind of get a sense of the room. How do you feel about this? When other people have your data, should you be able to find out what they've got?
Sounds reasonable.
Any comments on this?
I think absolutely. And this has more so come since I joined law school and started learning about what people can and can't do with my information and how much I don't know what people have about me. And so it's become something more concerning to me, just the vast amount of information that I can give away without really knowing. And that's now coming from someone who's learned about these laws, let alone someone who doesn't have any idea about what happens when they go to the doctor or, use 23andMe or whatever it is.
Yeah, any other, I have not found anybody who says, no, I think they should be able to take my data and not have to tell me what they have. I cannot find, I've been going all over America trying to find that person because I want to make a footnote and say I found one. But I can't find anybody to whom that just is completely obvious that I think we all sort of accept. And by the way, I wandered from the microphone. If you can't hear me, let me know and I'll go back and get in my box. But I have Oprah fantasies. I like to wander.
So I'll be a little bit of a devil's advocate, which is just, and you don't have to answer this, how much is packed into the word data in that context? Because, so my friends know some things about me. I don't know, do I have a right to know everything my friends know about me?
It's a really good question.
I'll just put it,
Put it that way. Someone comes in this room. You are in a public place. Someone comes in the room, a news reporter wanting to photograph us and takes a picture. Do you own that picture? Can you restrict how the photographer uses it? It pertains to you, it identifies you, it tells people that you were here, but is that personal information? What is data?
Mm-hmm. And I was just kind of wondering, like, my family members know things about me, and it might be, really disturbing to them to have me know what they know about me. Like, does your spouse or your lover have a right that you know what they know about you? I don't know. Maybe. But that is a kind of radical transparency.
Yeah, it is, and that's right. Your family isn't a HIPAA-covered entity.
No.
They're not a government.
That's why I was
So there's kind of two dimensions to this. To whom do we apply this obligation to respond? And then the second dimension of it is, what is the scope of what you can get from them? What is the permissible scope? A lot of physicians are very concerned. They'll jot notes when they're interviewing you. I think she's drunk. She needs to lose weight. She needs to do this. And they don't want you knowing they said that, and they feel very concerned that these observations, mostly the things that they suspect you of substance abuse, that it could be actionable if you get it. And they're very alarmed at this notion that you could get your charge. And with some legitimacy. They need to record their observations to be able to treat you and know next time when you come a year from now to check and see if you still have glazed eyes and look like you might have a substance abuse problem. And so they write this stuff down, but they don't want you to know they suspect you of it. It could rupture the trust that they need to treat you. So any thoughts? What should be the limits of what you can get from your doctor's files? Let's talk medical first.
I think that, so this is coming from total personal experience. I worked at a doctor's office and we did release all notes to patients if they asked for them with a record release request. And it had if it said, I think she's drunk, we never redacted that or anything. We just gave it to them because it felt like, I thought that was a HIPAA thing. I thought you had to give it to them.
You do, actually.
Right.
It is a HIPAA thing, but a lot of people try to interpret it that you don't, you know.
Well,
But it is in the HIPAA designated record set. Any other thoughts? Is there a reason to limit the scope of what people can get? Good reasons.
I mean, it seems like it could ruin the doctor-patient relationship as well. Like, there's trust issues. There's a lot of elements that could go in there where you don't want necessarily for the patient to know that you have that perception of them.
So taking that a step further, or at least building onto it, it could affect the physicians, right? They're not going to take notes the way they would. They're not going to be as candid. That's going to affect treatment.
That's part of the problem. Once you know that the data will be disclosed, does that affect what you record? Because it's only returnable under HIPAA if you maintain the information. So one way, if you're reluctant to have the data you record about people shared, is destroy the data. And that clearly wouldn't enhance good health care. There would be no records when you went the next time. So there are a lot of legitimate concerns about this. And then moving it over into the genomic data, it becomes in some ways more complex, but in other ways it's really, I think the genetic exceptionalism is probably not warranted. What's so special about low quality genomic data? There's low quality clinical observations in your health files, and you say doctors that are reading HIPAA carefully sometimes come to the conclusion they need to share it, because if they don't share it, you can't correct it if it's wrong. If you think your doctor is suspecting you of, say, some problem that you didn't know they were looking at, you may want to have a conversation with the doctor and say, no, that's not what the issue is here. So. But back to this, it became quite controversial when this HIPAA access right in 2014 went into effect, that quite clearly does apply to data generated in research at HIPAA-covered entities, and also can include data that would not be of a sufficient quality to use in clinical care. A lot of research data are with experimental tests. They may not even be accurate. You may be running the test to see if it works. It may be of a lower quality. It could be uncertain. Research labs may not be as careful about identifying your sample so that they mix up the results, and the test that's recorded under your name is somebody else's test. And that, although I have to say, I think a lot of research labs are doing a better job at sample tracking than a lot of clinical labs are. But this is a concern. You'll be giving relatively scientifically naive people data that may not be of a good quality. And the ostensible purpose of that, it's to protect their privacy, to let them see what you have. Let them assess, do these data provide a risk of discrimination? Is there information in my genome file at a research lab that later could be used to tie me to a crime? That may affect whether I'm willing to reshare that data for other projects, obviously, and could affect the validity of my consent to secondary uses of the data. And so this change just caused great consternation because the HIPAA access right looks so different from this well-developed line of thought about what is an appropriate ethical return of results. So what can we do about this? When you have two laws that seem to be in conflict, where you've got these CLIA regulations that are the laboratory regulations that seem to be saying you shouldn't report any individual results unless the lab is CLIA certified. But on the other hand, you have a privacy law that says, no, you need to share people's data. What do you do about that? Which should trump the other in the non-political sense of the word? Any thoughts?
Well, correct me if I'm wrong, but didn't you say at one point in the paper that the CLIA regulations rely on state law a lot of times? And so if the federal law is saying that you have a bigger access to privacy, there's a preemption argument. So.
Yeah, the way HIPAA has a very clear preemption provision. And the way it works is that HIPAA preempts any state law that gives lesser protections. And those protections include access. So if your state gives you less access than HIPAA does, then HIPAA would govern. So there's a federal floor of access. On the other hand, if states have a higher right of access or even a property right, a few states, 5 of them have a you own your genetic data type of law, that would trump. So there is this interaction of the state laws and the federal laws there. Then on the CLIA side, by the way, isn't that mind-numbing to have to read about the CLIA regulation? It's like this has become central to people's rights, and but it's pretty tough going reading about CLIA jurisdiction. How many made it through without having to have a cup of coffee? Think how bad it was having to write that. But it really has become a central issue. There is a perception that the CLIA regulation actually, you have a lot of research laboratories that operate without a CLIA certification under this exception that says as long as you don't return patient-specific results for clinical use, you can do that. And the agency responsible, which is CMS, which runs the Medicare program. By the way, why is CMS involved in regulating laboratories? You know, they're running Medicare payments. You know, they're kind of like bean counters. Why are they running our laboratory regulation system? Any thought about that? How did that happen? It happens in the late 60s. In 1965, the Medicare system went into place in the mid-60s. And it turned out that when Medicare became a big payer for healthcare, it became a huge payer for clinical tests. And it was realized that bad clinical tests waste federal dollars in several ways. One is the test is bad, but also it leads to inaccurate diagnoses, inaccurate treatment, and that costs more. So it was felt that in order to control Medicare costs, we needed a system to regulate these laboratories. And there were a couple of very visible scandals with bad pathology labs that were misdiagnosing cancer and really serious things. So in '67, shortly after Medicare goes into effect, they set up the CLIA framework, and CMS, as the one with most financial involvement, became the regulator. CDC helps them to provide some scientific help. But that's how that got in CMS. Then in '88, they updated the CLIA regulations, and that's the one we still have. Interestingly, that CLIA regulation, or the CLIA statute of '88, was just about the last piece of legislation to be enacted at the tail end of the Reagan administration. And it looks like Reagan-era legislation. It has this notion that federal agencies shouldn't use appropriated taxpayer dollars to regulate. They should get their money through user fees. So CMS's CLIA program is 100% user fee funded. It charges fees for the certificates that it issues. So it is an interesting case study in this debate that's gone on ever since about whether user fee funding of regulators causes regulatory capture. Maybe it does, maybe it doesn't, but that's kind of in the background here, is that you have a user fee funded agency that needs to be very responsive to its regulated entities. Now, can you give a valid consent to have your data be used for any purpose if you don't know what the data are? It's sort of like if someone comes to you and says, may I have your property to use for this good socially beneficial purpose? And you kind of need to know, are they talking about the old shoes in your closet or are they talking about your house? It's very material when you consent to know the scope of the consent. Interestingly, our research ethics never went down that path of thinking that a right of access is essential to the validity of a consent. The common rule and the counterpart FDA research regulations don't require access to data before someone consents. But this is one of the principles that was sort of enshrined in the late 1970s in that Privacy Protection Study Commission report. And then in 1997, when HHS designed the HIPAA privacy rule, that you can't have a valid consent to let your data be used unless you know. And that idea still hasn't really caught on throughout. You know, there's a lot of people that think that's odd, but if you think about it, it has some sense. You need to know not just how are they going to use your data, but for what. So the essence of this putative conflict of law is that, as I briefly discuss in this paper and discuss in more detail in another one, that conflict doesn't exist. CLIA only kicks in and requires a certificate if a laboratory provides patient-specific information or individual-specific information for a clinical use. None of these uses that are served by the HIPAA access right at a research lab are clinical uses. It's to enhance your privacy, to give you agency over your data, to enable some constitutional rights. People like to form social networks with people that have the same gene variants they do. They may want to lobby Congress for more research funding for this type of research. It's kind of this essential enabler of rights, and it's not for a clinical use. But the point that CMS has made in its policy statements about CLIA is that there's a pragmatic consideration here. If data are given by the lab for all these wonderful civil rights uses, the fact remains those data can be diverted into a clinical use. So if you give me my data to enhance my privacy, nothing's going to stop me from going on the web and using one of the many online interpretation services and diagnosing myself with it, and then showing up at my doctor and saying, I have these data, what do they mean? So does anyone see some merit to the position CMS has taken that once these data leave the lab, we can't be sure they won't end up in clinical use? Can someone speak to their point of view?
I think if someone gets their data and they try to decipher it themselves, there could be a huge interpretation issue, and then that could lead to more doctor's visits, more tests being run, just raise the price of healthcare in general.
Yeah, I mean, genetics, it's not easy, right? And there's a lot more that we don't know. And genetic counseling we don't have enough of them. So even if you wanted to go to a genetic counselor, it's not the most accessible thing in the world. So I think that just motivates you to want to find out on your own, go to Prometheus, and not that I have done that, but yeah, it's like once you get that result, you want to go find out what you have, and it's so easy now, and that's very inexpensive to have that interpretation. But even that's highly inaccurate because it's constantly changing. And so yes, I think once you have that information, it's a natural, like human nature to want to find more about it and see how that affects to you and how you can interpret it on your own or get the help of a clinician.
Yeah, I just want to drill in. These concerns that CMS has expressed are not completely frivolous. You know, they perceive a problem and they're trying to address it using the jurisdiction they have. And they are very aware of this potential for unintended use of data that are provided for a particular purpose. And right now, we have a critical staffing shortage of genetic counselors and trained medical geneticists. And there's an argument that this wastes their time. You know, all these people get their own data and they get alarmed and they show up and it tries to divert resources that really need to be kind of marshaled to treat people who have genetic conditions or cancer or serious illness. So there's this notion that that this free-flowing data lead to a misallocation of our healthcare resources. And you know, how big a concern should that be? Is what, you know, that's in one side of the balance, and on the other side of the balance is people's autonomous right to get their data. How do you weigh those? It's apples and oranges, so.
Well, I think it is a concern, you know, because medical resources are not, you know, they're not available just all the time for anyone and everything. And I think that there are people who have serious, serious complaints that need to be addressed. And if you have people wanting to come in and give information about, again, like you said, genetic factors, you know, that we don't even know what it means. Like, there's not even anything there to look at. They're taking all this time doing that. And I think also just, you know, it's money to go in and see a doctor. It's insurance policies, or the premiums are based on the risk pool. And if you have a whole bunch of people going in for kind of stuff that's not really pressing, you know, so it can raise expenses for everybody.
Any other thoughts about that? The concern is, I think that's, first of all, a perfectly valid concern. It's really a serious problem. Having low quality genetic information in circulation creates any number of problems. First of all, if you get a research finding that says you have a variant associated with future susceptibility to a serious disease, you're naturally going to want to follow up on that. And the way you would typically follow up on that is go to a doctor and ask for confirmatory testing. But it turns out your insurance doesn't pay for the confirmatory testing, because as far as your insurer knows, you're a perfectly healthy person with no reason to need this test. And it's still a rare event for these tests to be reimbursed by insurers. So now you have a patient who, as a result of receiving their data, either has to pay out of pocket to do a confirmatory test, or the doctor is kind of faced with this dilemma of, well, we've got this data, I don't know how certain it is, but it's all we've got. Should I try to go with that or force the patient to do confirmatory testing? And people can end up much worse off because now they spend a lot of money following up on things that their insurer won't cover. So am I convincing you yet that maybe we should protect people from having this information?
Can I throw one more thing in the risk? It isn't just money. I mean, people might have things done to their bodies.
Yeah.
There were women who had double mastectomies when they were in the early days of trying to figure out which variants of BRCA1 were deleterious.
Yeah. Yeah, that has been a problem. In the early testing, the first people to get tested are people who either have had a disease or have a strong family history. They are the ones that qualify first to get tested. So the early samples of data are people who have a pretty high probability of getting the disease, and they have the variant. As the tests roll out to larger and larger populations, and we start testing more and more people, for example, through lower cost services like 23andMe, you get a better sample of people, and you find out a lot of people have that same variant, but they're not sick. And so as you keep testing more and more people, sometimes the degree of association with illness declines over time. So people who run out and take medical interventions based on the early data may be getting an unnecessary intervention.
But it also feels a tiny bit patronizing to say, like, they might go and do something to their body, so I'm not going to tell them about this thing. Like, just whatever. If they want to do it, it's their information. And, like, hopefully, I mean, it's really hard to get a surgery that, like, alters part of your body frivolously. So there will be a lot of checkpoints in between, like the time where you get the information and the time where you have the surgery, that I think that, for me, that personal autonomy is more important than like hiding information because they could do something irrational with it.
In the argument, and I've always offended people when I put it this way, but I feel like certain groups of the bioethics community are telling me I'm too stupid to have my own data. And that makes me mad. You know, yeah, I'm stupid. I'm not medically trained, but I don't know how my car works either. And they let me drive a car. You know, I have no idea how that engine works. And so, yeah, where do we draw the line? And the reason I'm does this thing work? Let's see. We never have pens that work at my law school. So I always pull a Sharpie out of my thing and use it instead, and then I get in trouble. I'm really bored. It's kind of this question. Here's the lab. And a research lab generates low quality information for a whole lot of reasons. It could be using it for forensic purposes, just to identify people. It could be using it to test an uncertain new test. Low quality information has a lot of uses in research that are perfectly legitimate. So a lab will legitimately make some low quality information that really isn't ready for prime time in a clinical setting. And the problem with that, even low quality information can subject you to discrimination, stigma. It can be used by linking it to other data sets that are out there about you to re-identify your data. If low quality data are there, you are at risk in terms of discrimination, privacy, and so forth. So people want it. Over here we have the clinical setting. And the problem is we don't want, if we let high quality information out by, for example, saying this research lab has to be CLIA certified. It can only let out information that has clinical significance, well-validated clinical significance. If those data happen to leak into the clinical setting, there's no harm. But this low quality stuff, which has some very legitimate reasons people want it, but if it gets diverted into the clinical setting, that could do some real harm. But here's my question. I think this is the whole fallacy we've been stuck in for 20 years. The early response was that what we need to do, let's call this the gate of the laboratory. I call this the laboratory gate. The point where information leaves the lab. There was an attempt to keep low quality information out of the clinical setting by just kind of interdicting the flow of information from the lab. Wouldn't it be better to deal with this problem at the entrance to the clinical setting? Tell the doctor, we're going to deal with this at the clinic door. Instead of banning flows of information to people here, really scare the doctors. Say, you have a professional responsibility to inquire about the provenance of the data you're using. And if the patient comes to you with data and can't tell you where they got the data and can't show anything that would lead you to believe these are reliable clinical quality data, it's malpractice if you use it. And the doctors say, oh, no, we can't get their insurer to pay for confirmatory testing. It would be so mean not to try to help them with the data we have. Well, sometimes, and I think lawyers may know this better than doctors, sometimes you have to tell a client, I can't represent you. If you want me to do this study for you, doing it right is just going to take $100,000 of research. And if you put me on a $5,000 budget, I don't want you as my client. I cannot give you a professional legal opinion. And maybe we've been attacking this problem at the wrong end of things. Maybe the clinic door is where we need to be dealing with it. Let all the data go to the people and then put some serious controls on what can enter the clinic door. That's the policy we have not been exploring in this country because doctors don't want that. They hate to say no to a patient. They are trained to be very helping. And it's very hard to tell a patient who comes worried about something, I can't talk to you until you do a confirmatory test, especially if the patient can't afford it. But what would that look like? What sorts of controls would we put here to get some serious noticing about the quality of data and put it on the doctors instead of putting it on the lab not to communicate?
Just maybe basic, but first doctors would have to know what is the high quality data and how to screen which ones would need a confirmatory testing or further testing. Just because I don't think a lot of them have that knowledge now. Mm-hmm. So for them to make a discretionary decision, they would have to at least have the knowledge for themselves,
So maybe you put metadata tags on the data you're releasing that say this came from a research study. We have, with genomic testing, any particular genomic testing technology can be really good in certain parts of the genome and really bad outside its range. And you say, these data were in the range of the test, and these are, we have no idea. And really provide some serious disclosures and warning about quality. And then the problem is people would strip it off, but you can make files so that you can't strip it off without wiping the file. Maybe that's what we need to be doing. Is the big problem here the lack of insurers' willingness to pay for testing in clinical settings? Is all of this trying to just sort of work around that problem? Would it be a good idea to make insurers cover more of this type of testing?
I think even then you have the same front-end regulation need where insurers need some kind of information about the quality of what they're being asked to work off of, right? I think the blank check, the demand for the blank check out of the insurers is probably not a workable situation. And so how does CLIA signal to insurers that this is data good enough for them to pay for a confirmatory test for?
Yeah, that's the problem. And right now, even it's hard to get this type of testing paid for even in a symptomatic patient. If you have a complex liver cancer, your insurer may say you can have everything in the world, but we're not doing a genomic test, and it's going to be a big issue to convince them to do it. But a perfectly healthy-looking person walking in with some data they got somewhere and wanting a test, what would be the disadvantage of mandating more insurance coverage for this stuff? Any thoughts?
Oh, I don't know, insane costs and
Insane
premiums.
Genomic testing, I think at the end of the day, is going to be an uninsurable risk. Health insurance risk pooling only works to insure conditions that a few people will need this treatment, and then the ones who don't need it pay their premium and help cross-subsidize the cost for those who do need it. It's probably true that everybody in the population could get some benefit from having genomic testing. And so if it costs $5,000 to do the testing, basically everybody could benefit, so we just raise everybody's insurance rate by $5,000 to cover it for everybody. So that's one problem. Also, the genomic tests will reveal a certain number of variants. We all have them. And that'll require follow-up. And the current standards are if you show up with a deleterious variant, the standard of care is to test your relatives too. So you end up having this ever-expanding group of people who will need follow-up care. So at this point, I think the insurers, they don't have a model that can accommodate the costs of this. I think what we ultimately need is something that looks like a lifetime insurance policy for this, where you get it done, and then you get benefits over the course of your life, but the insurer who has your contract for this year sees no percentage in paying for this, because if it produces benefits, it may produce benefits 10 years from now when you're in somebody else's insurance program.
Is there a form of that lifetime contract that isn't single-payer government health insurance?
Yeah, is there? You could do an insurance contract. You can come up with a contract that'll do anything. It's like, I one time had a student that wrote a paper. It was actually a really good paper about this. You could do an insurance contract where I pay $1,000 to be insured against the risk that in the next year something horrible will be discovered about me that will make me uninsurable. And you could do it with some really creative contracting, but long-term cradle-to-grave single payer is one thing that takes care of that short-term incentive. But the other thing I think the insurers are facing is just that we know so little about the genome right now. It produces more questions than answers in a healthy asymptomatic patient. And so it just isn't something that seems like a necessary healthcare service for many patients. So I think these difficulties in addressing the problem here are what keep pushing it back and getting these policy statements that want to block it here.
I guess my question is that is there anything that could happen or policy-wise or any that would just make people address it here? Do you see like an actual realistic possibility of just addressing the difficulties and making that change?
I've been trying to think what that would look like, and I think you could go to the National Conference of State Legislators or that group that does the model laws and have them make a model law that just puts some very stringent penalties for physicians misusing data that have been clearly labeled as research use only. I think that would be very unpopular with the physicians, but I think it might also in the end come as a relief. Those of you who interact with physicians may have heard this, I'm sure you have. This is torment when patients come in with these data and say, I'm worried, the worried well patient, tell me what I should do. And there are only a few medical geneticists that really can have an opinion about that. And if you can come here, Vanderbilt, go to the Broad Institute, they can help you get an answer. But my experience of the healthcare system is I only interact with it when I crash a bicycle. And I crash in places like Wichita Falls, Texas, and get hauled into a little regional health center. And I think all the policy thinking we do sort of assumes that everybody can have access to Utah or Vanderbilt. And most of us will be going to the Wichita Falls Regional Hospital and asking doctors, and I'm not optimistic. And I think many of them would be relieved just to have a law that says we can't do this. We're not allowed to try to speculate. The other fear I have is that into that gap, the clinical decision support software, a lot of doctors will be relying on software to kind of tell them what these things mean. And Congress has, in the 21st Century Cures Act, tried to draw the line of when FDA can regulate that sort of software and when it can't. And that line looks very hard to implement to me. So I'm not sure FDA is going to be able to give effective oversight of the software that many physicians will rely on. So, help me though, what else could we do there? You pass laws that make penalties, you get really mean with tort liability, but tort is such a crude instrument for this sort of situation. What else could you do?
I also think we face, I'll say a bad version of the problem and a good version of the problem, okay? The benign version and the malign or malignant version. Doctors overtreat.
Yeah, they do.
And the malign version of the problem is they overtreat because they think they're going to make money. So look at all those bone marrow transplants
For breast cancer?
for breast cancer.
It was worthless. Yeah.
It was worthless. And patients went to court. Doctors were saying, this is, life-saving for my critically ill patient. And, patients went to court saying my bone marrow transplant. And insurers caved, even though it was still labeled, courts ordered insurers to pay. And, because the judicial system didn't know anything about it. And, there were bad motives in that. Some of it was let's make a lot of money. And some of it was, let's be famous for doing these transplants. At the time, when all these court decisions were coming down, I looked at the 50 cancer centers in the country that were the big federal ones. Half of them had patient testimonials on their website about how my bone marrow transplant saved my life. And it was a way to attract patients and get fame for their center. The benign version of it is that these doctors really believed it made a difference.
Mm-hmm.
And we're seeing a sort of lower grade version of that with mammography screening.
Mm-hmm.
The American Cancer Society doctors went crazy when there was a suggestion that it should be between women and their doctors whether you get regularly screened at 40 or 50. And there are a lot of women having surgery for what might never have become a real breast
An
cancer.
aggressive cancer.
Yes. And, there's a bad reason and a good reason. And, I was totally convinced by your argument that it's a bad idea to just lock it up. But how we deal with all the green stuff up there.
The reason I'm kind of belaboring this point is I wrote this article from the perspective of someone that's obviously very attuned to the desire people have to get their data, and many good reasons why. Congress has viewed this as a civil right for 50 years. Adding the genetic data to it under GINA was sort of a recent enhancement. But this is really core to our whole system of federal privacy law, that people should have a right of access to their stored data. And so I like that. But I don't want to leave you with the impression that the concerns on the other side are spurious. There are cost, practical issues, dangers to people from sharing the data. Now, I don't think that's the end of the story. I think there's some, I kind of view this in a First Amendment analysis perspective, that if you're going to restrict flows of information, you need to do it in the best tailored, least intrusive means. And putting a warning on it is a lot less intrusive than banning the flow of the information. There's a lot we need to do to make the steps we take to manage the problems as unintrusive and as affirmative of people's civil rights as we can manage. But it's not a simple problem. It's not at all a simple problem. And I think it's one that isn't quickly resolved. I think as we develop more power to interpret what genomic information means, people have even more appetite to get their data, and the potential for deleterious uses will go up as it becomes more predictive.
Yeah, I was thinking of that as precision medicine gets more popularized and we're seeing more results and being widely used, and I can see consumers wanting that low quality data and going to the clinical setting even more, because it's going to be out there. It's going to be, the results are there, it's happening, it's going to be beneficial.
So, in another class I'm in, we're talking about how companies like 23andMe and Ancestry DNA are toying with the possibilities after, their databases are growing and they have all of this DNA information. They're toying with the possibilities of disrupting healthcare by being able to be precise with this type of information and basically enabling patients to, one, either cut out doctors, for basic care, blood testing, certain things like that, but also sort of hold doctors' feet to the fire by coming in with this information and saying, I want you to test me with this, and then if, for example, they don't, then having some type of malpractice suit or something that they could bring against physicians. Or anyway, those are just two examples of a broad discussion about how when I was sitting here and thinking about high quality and low quality information and clinical setting and research setting, and it seems like that's exactly what we were talking about, but here we're talking about the policy implications, and there we were talking about the business implications, right? So my question is, do you see that becoming like a growing concern in the next, immediate few years? And also, would that be the beginning of something to build up the clinical side, right? Doctors saying, well, if we're going to start being held liable for these things, then we are willing to, not only because it's a pain and we don't want to deal with this information that we have to guess on, but there's real insurance implications, malpractice insurance and things like that. Do you see that possibly being a way?
Well, I think you put your finger on something that is going to be kind of definitive of the next 15 to 20 years of healthcare and how it evolves. And I think what that is that not just the genomic test, but some of the molecular biomarkers, your circulatory system touches, the blood touches every organ system as it transits your body. And when it goes through each organ, it picks up proteins. And if we can just get to the point of being able to see what those mean, we're, I think, not too far away from having effective diagnostics that can say, oh, your blood has a protein that says you're about to get kidney cancer. And what this brings is a paradigm shift. Always before, the clinical setting has been what I call the hub of healthcare. It's the entry point where patients go. They go to the physician or the clinic as their first stop in seeking healthcare. And the clinical setting determined what tests you got. Doctors ordered the test and told you, oh, with your symptoms, you need to go to the lab and get this test. I think we may be very, very close to a flip in that, where our primary healthcare relationship will be with the diagnostic lab. And I'm not talking about the research stuff we were talking about, I'm talking a clinical lab. And that's who you'll keep touch with. And you'll have your smartphone, we'll have the little attachment so you can do your blood prick and it'll send beam the information. And the lab will call you up and say, we're ordering you to go to the doctor. We've seen something that needs a doctor to treat you. So this is vying to become the central hub of healthcare and the patient interface. And these guys, instead of them ordering you to go get a test, these guys will order you to report to the doctor because you're 6 months away from getting cancer. And that is going to be a major shift. And I really think it could happen. I think it's in your lifetimes, in your careers. And I'm kind of relieved about that. You'll have to deal with this. But that reordering is profound. Our whole healthcare financing system would change. Our whole, the web of relationships. Labs have been highly effective throughout the history of modern clinical labs at sort of not having as much liability as you would expect, given the importance of how they affect healthcare. For one thing, they're very savvy about settling. When something's a loser, they settle it and don't create a precedent. So every case against a lab tends to be, for the courts, a case where there are very few precedents because the meritorious cases tend to settle, is my impression. If you pull like on ALR or some of the treatises that summarize law for clinical misadventures, I mean, a huge body of law. There is some laboratory liability, but not in proportion to what you see. For this to be the hub of healthcare, you kind of need to have more responsibility there than this sector has yet stepped up to take. And so I don't know how it plays out, but I think we're in this, the technology is close to being there. It's not quite there yet, but when it is, and it'll be maybe as soon as 5 to 10 years, what does the healthcare system start to look like? I would love to just have my smartphone do my testing, and I would never go to the doctor except when I got a little text that says, oh, you better go. That would be great. But trying to negotiate that and all the you end up with these very dysfunctional transitional states when you have an industry that's transitioning, where these guys still have all the liability, but they don't really have the control. You get in these perverse transitional states that really cause a lot of difficulty. And how do you transition through those to a workable order? And again, I'm afraid you guys are the ones that are gonna have to figure that out. Because I think it is fast upon us that there's this tug of war happening. But I digress. So any more questions?
So I've got a whole bunch here. Some of them I think have been partially answered, but here's one that, so what mechanisms do you think are available to help patients understand? I mean, assuming that ordinary doctors are probably not really good at it. Genetic counselors are not available. What are the mechanisms that might be there to help? I mean, if the lab is going to let out the information.
I like the online interpretation services, but the ones that link to literature, that's a very big ask to ask every layperson to be able to navigate that. But sometimes as a medical layperson, do you ever go to the doctor and realize you know more about your medical condition than they do? It happens, you know. We need to empower ordinary people, but many people just don't have the interest or don't have the attention span to want to do it. I think commercial interpretation services, unbundled interpretation services have a lot of promise. Some of the objection with research data is that research labs feel they have an ethical duty not just to return your information, but to help you understand it. That takes a lot of time. The HIPAA access right is a much cleaner right. You get your data, it's up to you to figure out. So if you want it interpreted, you need to go find someone to interpret it. I think a developing market and unbundled interpretation services could be beneficial. This presumes building a workforce of genetic counselors, and then I favor having some sort of grading for these entities. It's very hard to pick which ones are good and which aren't, but you could have a certification process for interpretation services, perhaps. It's a whole market that needs to be built to meet that need. Is that a complete solution? Not at all. The ultimate thing is that whether or not we make this the sole point of control, we have got to get doctors to start, just to stop operating on people based on bad data. That should just be malpractice. You do a confirmatory test. If someone comes in with a direct-to-consumer test or research data, you do not do surgery on that person until you do a confirmatory test. That's just, and there needs to be some steep consequences for that. The physicians ultimately are knowledgeable and need to, and I think most of them do. I think FDA tried to find examples of people who've been harmed by low-quality genetic data, and they studied it really hard, and they came up with 24 examples. Doctors are doing a pretty good job controlling this, but it takes a lot of their time, and it's very stressful for them. Because if you don't intervene and the person does come down with the disease, that's a bad outcome. Other questions?
Yeah, another question I have is about, well, I'll just read the question. I'm interested in knowing what lobbyists contributed to GINA. Who were the biggest proponents and opponents of the Act and the individual access to genomic data provisions specifically? I'll add in my own, did that just kind of slip in under the radar? Were people actually lobbying for it? And what groups are now lobbying to amend it? I imagine researchers and consumer protection groups have weighed in. Are there any other groups that have a large stake in access to genetic information?
There are various stories about the birth of GINA. Some trace it to the National Institutes of Health Ethical, Legal, and Social Issues study program, which funded a lot of research into the impacts of the Human Genome Project and expressed a lot of concern about genetic discrimination.
We have 3 people at this law school funded under that program.
Exactly.
Yeah.
And that this raised awareness of this potential for genetic discrimination such that it became an issue, and I don't know about who had lobbied for it or not, I honestly don't know that, but the consciousness raising about the potential for harm from genetic discrimination was raised, I think, out of the scholarly community to a large degree. They could foresee the potential that, and in those days we thought this was going to be a lot more predictive than it is. It hadn't panned out yet. But that this could really stigmatize people. I had that theory that you kind of expressed just now, that maybe this privacy provision of GINA was an accident that just kind of slipped in. That it was legislation intended to deal with insurance and employment discrimination, and this just, Congress, they don't read what they pass. I actually went back through the congressional records, went through the debate, and they specifically discussed the privacy provisions before they voted on it. And there were kind of 2 concerns expressed. There was one group, and this was in the House and in the Senate, one group was saying, we got nothing now. You're putting it under HIPAA, we'll have something in the way of privacy protection. So this is something we need to do. It's fine to ban certain discriminatory uses, but there are a lot more discriminatory uses that GINA didn't address, such as life insurance, etc. And so privacy still is one of the ways you protect against data going astray. The other side that was vigorously discussed was that HIPAA is such a weak privacy regulation that lets your data go all sorts of places without your consent. This isn't enough. We need something much, much stronger. We need special purpose genetic privacy legislation. This making HIPAA do double duty is a very poor solution. And some of those lawmakers said, and we're going along with this because it's better than nothing, but we will return and try to get what we really need, which is a forceful genetic privacy provision, much more forceful than this. So, but as to who lobbied for it, who wanted it, I don't know. And I just also want to point out, we have a very piecemeal framework. The Privacy Act, if your data are in a governmental database, you have access to it, and some privacy protections and some limited consent rights. If you happen to have your data stored in a HIPAA-covered entity, you have limited consent rights, a right of access, kind of the same package you get, except now it's in the private sector. But everywhere else, there's nothing federally. Direct to consumer, testing services, medical device manufacturers that make the tests, they're not HIPAA-covered entities. And so if they have your data and you don't have any of these rights, that's where the states have stepped in a lot of cases. There are a lot of states that have an access right. And in that case, it's more stringent than HIPAA, so the state law prevails. But we still, in the universe of where our data are stored, there's these vast expanses where you have neither a clear privacy framework or an access right. It's law of contract. If you get a at-home medical device, or not a medical device, but a medical device or a wellness product, it can be beaming your data back to the manufacturer, and it's the law of the contract. What do the terms of service say? And they're not in your favor in most cases. Scott Peppett is a scholar who did a nice survey of those terms of service for those.
So one other is, what other practical uses of this kind of genetic information might there be for patients for people outside of the medical context?
Yeah, that's where I see the biggest benefit in the research quality data, because the research quality data should not be used in clinical care. It's just not for that in most cases. Citizen science. There are groups of people who have a child with a rare disease, and they know the disease is so rare, it's probably never going to get big funding from the usual sources. And some of these groups have got together and found other people like them, and sometimes they funded research, sometimes they did it themselves, and in some cases come up with therapies that help their child. So citizen science is really important. One is being able to donate your data to whichever study you want to. Research institutions kind of like to keep the data because it's fuel for future discoveries, and if you can get your data, you can go give it to another institution and help actually get to a large-scale genomic data commons that would be a huge asset for discovery. I think that almost has to come bottom up from the individuals rather than top down, because as an individual, I can give my data to whomever I want. Institutions can't. They have all these privacy laws on them. I can also sell my data for remuneration, and there are times when that might be a good tool for make a market in data. That's going to have to be individuals selling their data because the institutions have constraints on their ability to take remuneration for sale of data. So that's another one. The other one is just for entertainment, for people like to know things about themselves. It's fun. And social networking. Also just showing you some respect. This thing that we're too stupid to get our own data, maybe they're right that I am, but I want it anyway. It's just a dignity thing.
There was a flip side of that, which is if individuals control, will we ever get the big data sets we need for statistically significant results? That's the last question I have.
Yeah, and I've been on that side of this issue, that you need unconsidered access because consenter's bias can be a real thing in some contexts. The people who consent to let their data be used are not like the people who don't consent. Some of it makes sense and you can explain it, some of it doesn't make sense, but there are quite a bit of empirical studies that people who consent are not representative of the whole population. And so, there is a time and place for the unconsented access. And sort of the grand American bargain that has been made since the 70s is, we'll allow some unconsented access, but the quid pro quo is if other people can get your data without your consent, you should be able to get it too. And that principle has really been taking a beating. It's never really caught on, but it's a good principle.
Well, that's it. Yes, last question.
Okay. Just kind of relating to that, have you seen any information or data about those who do consent and how it has furthered health disparities among different ethnicities that don't have access to getting their
Are you
gender tested?
just saying the fact, like in our clinical trial population, for some reason, older white males tend to consent for research more than other groups, and it skews the data. It leaves a lot of groups without therapies that have been proved effective for them. It leaves women often without therapies so is that what you're
Yeah.
It's a real problem, but the thing is, how do you fix it? Are we going to just coerce people and say everybody's got to enroll in research? That would get rid of the consent bias, but it's battery in a clinical research setting. But with data, not so much. Touching people's data isn't like touching their bodies. It's not a battery. So maybe we need to be a little more inclusive and in taking data without consent to try to resolve health disparities. I don't know, it's just people have legitimate different views on it. But I'm all for some taking of data to address concerns and to address health disparities. I'm not for doing it with clinical research, so obviously.
Thank you so much. There's tea, so stick around and talk. Lots of opportunity for informal conversation.
Some jams.